I want to introduce our last capstone speaker, who is an incredibly important person in the state of New York and nationally. And we are so grateful that Attorney General Tish James has been willing to offer us some thoughts on the ERA and its importance in New York, but also globally. We do have an ERA pending before the New York State Legislature that is actually more broad in its language than the national ERA. And I know Attorney General James has been supportive of that effort, as she is of the national efforts to finally ratify the ERA. Tish James is the 67th Attorney General of the state of New York. She was elected Attorney General in 2018 and recently re-elected to that position by an extremely wide margin. She's the first African-American woman to hold that position of Attorney General of the state of New York. She received her BA from Lehman College, a law degree from Howard University Law School, and a master's degree in public administration from Columbia University School of Public and International Affairs. General James has built a career in public service, serving on the New York City Council, as New York City's public advocate, and then of course now as our Attorney General. So please help me welcome Attorney General Tish James to leave us with some thoughts about the future of the ERA.
Hello, everyone. This is Letitia James, Attorney General of the state of New York. In May of 1969, one of my sheroes, the late, great Shirley Chisholm, addressed the United States Congress about the Equal Rights Amendment. She said, "Existing laws are not adequate to secure equal rights for women. Sufficient proof of this is the concentration of women in lower-paying, menial, unrewarding jobs and their incredible scarcity in the upper-level jobs." I want to thank all of you for coming together to talk about a topic that is timely. 4 decades before Shirley Chisholm spoke, in her day and today, decades after her words. I want to thank Columbia Law School and especially the ERA Project, the Center for Gender and Sexuality Law, the Columbia Journal on Gender and Law, and everyone involved in this important gathering. A lot has changed since the Equal Rights Amendment was first introduced in Congress. In 1923, we have seen the pendulum swing in the direction of rights for women, and women taking on roles and careers in ways that were unimaginable to our grandmothers. But that does not mean the argument about rights for women is over. That does not mean the pendulum will move in its present direction. It can be stopped in its tracks or swung back. So the landscape we live in is different today, but the essential argument about women's rights and therefore about the ERA has stayed the same. My thoughts on this are clear. We needed an ERA a century ago. We needed one in Shirley Chisholm's day, and we need an ERA today. Because whenever the pendulum swings on rights for women, someone is always trying to swing it back. What I would like to do now is talk about how an attorney general like me could use the ERA, whether that ERA is on a state level or federal level. Now, my office defends the rights of women under existing law. We do it well. We will continue to do it well. But my office could defend the rights of women more effectively and more definitively if there was an ERA. Here are 5 ways the ERA could help us. 1. Sex discrimination cases would be brought under the strict scrutiny standard. As you know, the current standard for deciding sex discrimination cases is complex and unwieldy, and it allows an unsympathetic court to water down protections. Having the ERA would force the government to show proof of, and I quote, a compelling interest for the government to treat people differently based on gender or gender identity. And that higher standard could help us win cases. 2, Title IX would be strengthened. We bring cases under Title IX, and Title IX protections can be watered down or reinforced by presidential rulemaking. If or when a future administration tries to water down Title IX, as the Trump administration did, the ERA would give added weight and tools to anyone suing to stop that effort. 3, protections under the Pregnancy Discrimination Act would be strengthened. That piece of legislation has been vital to keeping people at work and for longer. But courts have been able to interpret its protections far too narrowly. The ERA would add argument to expanding those protections. 4, access to reproductive health could be further protected. We have watched as the right to choose has been chipped away in many states. Having the ERA could address some of those efforts. For example, states' ERAs in New Mexico and Connecticut have been cited by courts when striking down laws by prohibiting Medicaid payments for abortions and contraception. 5. The Federal Violence Against Women Act would be strengthened. This legislation originally allowed survivors to sue their attackers in federal court. That provision was struck down, and that could be revisited with the ERA on the books. Let me conclude by saying that the historic argument over the rights of Americans will never end. As President Kennedy said, democracy is never a final achievement. It is a call to an untiring effort. Passing an Equal Rights Amendment will not put an end to the historic argument you're discussing at this symposium, but it will help people in positions like mine, attorney generals all across this nation, win more legal arguments, help more people, and bring us closer to being a nation that secures the blessings of liberty for everyone, a more perfect union. Thank you.
Thank you so much, General James, with those parting thoughts. I'm going to hand it over to Ting Ting Cheng, who is the director of the ERA project, to help close us out.
On behalf of the ERA project, we want to extend our deepest gratitude to Attorney General James, our co-sponsors at the Columbia Journal of Gender and Law, our incredible brain trust of speakers, and our lively attendees. I want to give a special thank you to our ERA project team, Catherine Franke, Lilia Hajivanova, and our colleagues at the Center, Liz Platt and Candace Bontario, for being wonderful colleagues and thought partners in the symposium. What an effort. The ERA asks society to commit to permanent protections of sex equality. What could be more essential than that? That's why we exist. The ERA project was created to realize that promise of substantive equality that meets the needs of today. Our symposium framed the ERA as an essential democracy project that thinks about equality's connections to fundamental citizenship, basic autonomy, justice, liberation, and freedom. We hope that the symposium provided the hope that real change is possible in a dark time and charted new paths for the equality movement of today. Our speakers powerfully reminded us of what is at stake when we're talking about the ERA, who the fight is for, and who the Constitution is actually for. Not those sitting on the Supreme Court or even the most privileged in society, but for the people who would benefit the most from an ERA. We hope that you're all energized to transform this knowledge into action in support of the ERA. Thank you for being here again, and please visit our website for more on our work, more on the ERA, and to follow us on social media and to support the work that we do. Thank you and have a wonderful weekend.